Thank you, Mr Acting Deputy President. I present the report of the Select Committee on the exposure draft of the Marriage Amendment Same-Sex Marriage Bill, together with a Hansard record of proceedings and documents presented to the committee, and move that the report be printed.
Question is that motion be agreed to. Those of that opinion say aye, against say no. I think the ayes have it. The ayes have it. Senator Fawcett.
Thank you. The definition of marriage is an issue that is deeply held by many in Australia.
Senator Fawcett, you just do need to move that the Senate take note of the report.
I move that the Senate take note of the report. And I reiterate the fact that the definition of marriage is an issue which is held deeply by many people in Australia, and accordingly the government's position has been and continues to be to allow the people of Australia to have their say via plebiscite on whether that definition should change. It's a matter of record that the government's legislation to enable a plebiscite was defeated in the Senate last year in November, but it still remains the government's policy position. As part of the preparatory works for the plebiscite, the Attorney-General released an exposure draft for comment, which has now formed the basis of a vote by the Labor, Green and NXT parties to create this select committee to examine the exposure draft with a particular reference to the requirement for or efficacy of religious freedoms. I think it's important to note that evidence before the committee confirmed that Australia is not required to make a change to the definition of marriage under jurisprudence in international law, but nor is there an impediment to it doing so. The United Nations Human Rights Committee has made it clear that so long as a nation has legislation to both recognise and protect same-sex relationships, as Australia does, then the right to freedom from discrimination and equality before the law is fulfilled. And that's because under the International Covenant on Civil and Political Rights, marriage, in particular Article 23, is defined as being between a man and a woman. And the European Court of Human Rights has made a number of judgments in recent years supporting this approach. The context of this inquiry, and that's what I'm coming to here, the context of this inquiry, therefore, was not that a change isn't inevitable, but if a future parliament chose to legislate for a change in the definition of marriage, that it would potentially enliven the right to the freedom of thought, conscience and religion in a range of areas. And evidence to the committee demonstrated that there are substantial matters of human rights law to be dealt with that extend well beyond the Marriage Act itself. And so if Australia is to remain a plural and tolerant society where different views are valued and legal, legislators must recognise that this change will require careful, simultaneous consideration of a wide range of specialist areas of law, as opposed to the common perception that it involves changing just a few words in one act in Parliament. And people on both sides of politics who support a change have made comments in the past to the extent that it's a quick and simple change, but what this inquiry has demonstrated very clearly is that there are actually quite extensive areas that need to be considered. And if Australia is to remain that plural, diverse community where different views are protected, then those changes need to occur in a coordinated manner, not with some lagging others, particularly given the record in Australia of previous attempts to align or reform laws such as anti-discrimination laws across the nation. As Chair, I wish to record my appreciation for the collegiate manner in which members of the committee and witnesses have approached this inquiry. The members of the committee and the witnesses come from a wide range of lived experiences and positions on this topic. They have different understandings of how the institution of marriage should be defined, and yet despite that, I'm pleased to report to the Senate and to the Australian public at large that this has been a good example of where legislatures can work constructively together to explore the differences and to place on the public record a report that identifies these fundamental rights that must be carefully considered, respected and balanced in any future legislation that a parliament may approve. So having provided that broad contextual statement, I would just like to touch on some of the key points of the report. The report is split into two large areas. The first deals with the exposure draft itself and particular provisions in that, but fairly quickly then moves into the third chapter, which deals with the issue of human rights, which is where much of the discussion occurred in terms of which rights apply and how they intersect, and where they intersect, how they should be balanced. And that issue of balance is important, and the committee was particularly seized by the comment by Professor Patrick Parkinson, who indicated that on this topic, balance does not mean that one right is crushed under the weight of another. And in fact, that lines up with the international jurisprudence and guidance on this issue that says that nation-states should lean towards supporting the right, and any limitation must be subject to legitimate purposes and be reasonable, and the least amount of impact that can be used. So Australia has signed up to 7 core United Nations treaties, and in general what those treaties show is that any limitation must be prescribed by law, be in a pursuit of a legitimate objective, and be rationally connected to its stated objective, and be proportionate in the way to achieve that objective. And so the rights that we're talking about here are Article 23 of the International Covenant on Civil and Political Rights, the ICCPR, the right to non-discrimination and equality in Articles 2 and 26, and Article 18, which is the right to freedom of thought and religion and conscience, which is split into 2 parts, one being to hold it and one being to manifest it. As I mentioned in my opening comments, there is international jurisprudence that says that Australia has no obligation to change our current definition of marriage because we do not offend under international law, any human rights law, as long as we provide an alternate recognition for same-sex relationships. That position has been challenged by a number of people who claim that the case of Jocelyn, being 17 years old, is now outdated. But given that there has been no subsequent judgment by the Human Rights Committee, and that the average in terms of judicial authority cited by courts is over 18 years, then the proposition that something that's 17 years old and hasn't been superseded should be ignored is hard to sustain, particularly given that the European Court of Human Rights has in recent years had 4 judgments that go to very much the same outcome. Now, there's been a lot of discussion around how to balance the rights, and the area that I'd just like to focus on, and there's many, and I'd encourage people to read the report, because what we have managed to do across the committee members, all of whom basically come from different lived experiences and perspectives, is provide a committee report that everyone has signed up to. There's no dissenting reports in this, because these are the issues that we hold need to be debated carefully and considered carefully by any government that moves ahead. But there are areas, for example, whether the freedom for religion should be treated as an exemption or whether it should actually be a protected right, whether it applies just to organisations, as is the case with much of our anti-discrimination law currently, or whether, as our obligation under the ICCPR clearly indicates, it applies to individuals. And the question then is, how do we make sure that we allow people to live without discrimination, but at the same time allow people to exercise their individual freedom of religion and conscience and belief? Some of the arguments that go to that focus around whether discrimination is solely on the basis of a protected attribute, or whether it's in conjunction with, in the case of marriage, a union of 2 people who may have that protected attribute. And I think that's an important distinction for Parliament to consider when it debates this in future, because we've had cases put to the committee of where individuals have demonstrated over years of practice, of, for example, running a business, that they do not discriminate solely on the basis of protected attribute. In fact, some had friendships and long-standing client-business relationships with people who were same-sex attracted. But when it came to the institution of marriage, they chose to say we'd prefer not to provide a service. Now, that was a step too far for some people, but it's indicative of the kind of deep issue that any future government would need to grapple with should a bill pass in this area. Again, people who came to this don't necessarily agree. I'm a supporter of traditional marriage and I'd like the definition to stay as it is, but this, I think, is an important piece of work because if the Parliament ever chooses to go down the path of changing, these are the scope of issues that we will need to carefully consider in order to keep Australia a diverse and plural society.
Thank you, Senator Fawcett.